The next two presenters are going to talk about why the right to counsel matters, and we couldn't have two better people to address that. We've got somebody who serves as the general counsel to the county judges and commissioners and trains all across the state, works closely with counties, and then we have a leading judge from West Texas, Judge Rusty Ladd, whose county has been extremely progressive in moving forward indigent defense practices. They've set up a managed assigned counsel program tailored after San Mateo County, California. They've put in place a regional capital defender serving not only 70 counties now, but close to 120 counties. Some tremendous leadership from Lubbock County. So we will have a gentleman from West Texas, Judge Rusty Ladd, a gentleman from East Texas, Jim Allison, explaining why the right to counsel matters, and we'll begin with Judge Ladd.
I stand before you today as a confused and disoriented person. That's because I'm a Texas Ranger baseball fan who personally witnessed Cliff Lee mowing down Yankees in New York last week, and I can't understand why he couldn't do the same thing in San Francisco. So we'll see what happens tonight. I'm talking to you about why the right to counsel matters. I doubt that you'll find anything that I say worth writing down. Indeed, I'd appreciate it if you just kind of put your pencils down and just listen for a few minutes while I talk to you. And here's, if you wanted some kind of breakdown, they always tell you to give 3 ideas. Here's the breakdown of what I'm going to be talking about. The right to counsel matters because I got to go to sleep at night, and so do you. The right to counsel matters because there ain't no parachute on the airplane. And whenever somebody is trying to represent themselves, then they're flying a plane that there ain't no parachute on. It's a matter of simple justice. The third reason is what I'm calling the Nuremberg Effect. We'll talk about that in a second. Let me give you my resume. I spent 7 years as a police officer in Southern California and Texas. I spent 1 year representing people, mostly in a criminal defense capacity in Amarillo, Texas. And then I spent 10 years as a prosecutor. The last 4 of that, I was part of Lubbock County's kind of chief deputy by committee. There were 3 of us that were really all in a chief deputy capacity. In the course of my prosecutor career, I sent scores of people to prison. I was first or second chair on 3 capital murder cases. We got death penalty sentences in all 3 of those. 2 of those guys have been executed. I handled at least a couple of dozen murder cases. In that span of time, in 10 years, I got 3 not guilty verdicts on felony cases. And I remember getting, I think, 4 not guilty verdicts on misdemeanor cases. I was a very good courtroom prosecutor. The only reason that is important for you to know is to judge my own credibility whenever I tell you this. Whether I was trying a DWI case or capital murder case, I wanted defense counsel to be good. I wanted the defense counsel to be at the top of their game on the day whenever I was in court. I wanted the judge to be awake and alert to what was going on and to know what the hell he was doing. I wanted those things to happen because I was using all of my, I think, pretty considerable skill and talent to potentially ruin somebody's life, to seek their execution in 3 cases, to send them to prison and lock them up for decades. For at least in a DWI case, to force upon someone the stigma of having a conviction that would seriously impede their ability to be successful in life. That was my job, and I was proud of that job. And I still am proud of that job. But whenever I was trying to get that done, I wanted the other side to be good at what they did. Because I got to sleep at night. And whenever I walked into court and I was trying to do those things to somebody that I believed justly deserved that consequence, then I wanted someone to be on the other side who had the ability and the capacity and the guts to challenge me, to make me prove my case. Because on my best day, as smart as I think I am, I did not have all the answers. As wide open as I am, as wide-eyed and alert as I can be, I was blind because I only had one side of the case. I didn't have all the facts. I didn't always have the correct theory of the case. I needed somebody else to challenge what I was doing. Because I don't sleep well at night. Whenever somebody goes to jail for a single day, much less somebody gets executed, and I'm questioning whether or not they had competent, gutsy, able counsel. And you've got to sleep well at night too. I realize there's a lot of folks in here that are not lawyers. But you're the influencers, perhaps the judges, perhaps the commissioners, perhaps the coordinators in some kind of program, who have the ability to visit with the commissioner, have lunch or have coffee and say, you know what, I was at this workshop in Austin and I've been real convicted that our conviction deal here in this county needs some help along the way. You're the people who help make those decisions. And if you're not doing your job, you should not be sleeping well at night. We went to law school as lawyers for most of 3 years. And most of us graduated, I guess, if we managed to wind up getting our law degree. You know, and that's a funny concept. I tell people, if you read my bio, you see it says that I graduated from Lubbock Christian University back in 1975. I tell people, I didn't graduate, I escaped. You had to have a 2.0 back in 75, and that was in the day and time when a lot of universities were being pretty kind on their grade point levels. The draft was on. There was a war going on. It was just winding up. And those college professors didn't really enjoy flunking somebody out to see them get drafted and go to Vietnam. It was a fairly kind era. Even in that kind era with grades, whenever I got out of school, you had to have a 2.0, and I had a 2.0. Not one single bit more. I did a little bit better when I got to law school. But still, law school was a complicated affair. Being involved in the criminal justice system is a complicated affair. Whenever you're sitting as a judge, and I've been a judge in a misdemeanor court for most of 11 years now, and it's painful to watch a lawyer who doesn't know what they're doing. I recognize, and I tell people all over my county, that a county court of law is a training ground. Judge Farmer, my colleague from Lubbock County in a misdemeanor court over here, and other misdemeanor folks, you recognize that a misdemeanor court's a training ground, and there's a lot of reason why that's true. You want somebody making their mistakes on those criminal trespass cases. As hard as it is to admit, I would rather somebody in my courtroom make a mistake on a DWI than make a mistake on a capital murder case downstairs. It's a training ground. And I realize my responsibility as a judge to provide adequate training and to walk that really thin, snaky line between trying to make sure somebody gets adequate training as a judge and trying to make sure that I'm not interfering with the process, that I'm still being the judge and not the lawyer. And sometimes I don't know when I cross that line, and sometimes not. And I would really appreciate it if you did not ask the lawyers in my county how often that might happen. But there is a real complicated process that a person finds themselves in. If it's excruciatingly painful to watch a lawyer who doesn't know what they're doing, then watching some poor dummy, Miss Wiley, who is charged with an offense, and I'm sitting there thinking there is no fool like the fool in front of me this very minute, because he is saying, Judge, I want to represent myself in this case. Okay. You have a constitutional right to lawyer, and you have a constitutional right to represent yourself. Now, I've been accused in my county of having a court where people are not permitted to represent themselves. It's not true. I do have a court where I don't make it easy for people to make that decision to represent themselves because they don't know what they're getting into. But if somebody says, hey, Judge, you know what? I've been the lawyer route. That didn't work out so well for me. I want to represent myself. Okay, you can represent yourself. But understand, that's like being in the cockpit of an airplane. And it doesn't have to be a big airplane to be complicated. It can be a little old bitty Piper Cub. If I was in the cockpit of that airplane, then please understand, there's no parachute in this thing. So whenever things start going downhill fast, as they almost inevitably do when you represent yourself, you're not going to be able to jump out halfway down. You're stuck in a very complicated procedure. Now, most of us have this feeling of compassion for somebody that's an underdog. We felt that way about the Texas Rangers for the last 25, 30 years. We have a feeling of whenever somebody is in an uneven match, it's just fair for them to have somebody on their side, even if the person's been charged with some kind of offense. Simple justice dictates that somebody that's involved in as complicated a process as our criminal justice system can be, whenever they do have the formidable forces of police, prosecutor, investigators arrayed against just little old them, then simple justice would seem to say it would be proper for them to have somebody on their side who understood some of the complexities of this cockpit, because there's no parachute on this place. I think especially for folks who are in your situation, facilitators of the criminal justice system, perhaps not the lawyers, but the facilitators along the way, then the last thing I want to tell you about is the Nuremberg Effect. And if you recall the movie Justice at Nuremberg, there's this profound scene for anybody who truly believes in the integrity of the American experiment with democracy. There's this profound scene. And if you're younger and you're sitting there thinking, I never heard of that movie, then you ought to look it up. Spencer Tracy, in my book, one of the best actors that ever drew breath, plays the part of the judge, the American judge, who's presiding over the war crimes. This is the second level war crimes. They're not talking about the guys who led the Nazi government. Those are not people on trial. Those had already happened. Justice at Nuremberg concerns the judges and the prosecutors who were in the German Nazi state, who had allowed things to get grossly out of hand. Burt Lancaster plays the role of the German judge, who was a celebrated jurist, not only in Germany, but across Western Europe during his time before the Nazi state took over. And he's convicted, and he should be convicted, because he had allowed unjust things to happen in at least one case. And it was that case that was the focus point of much of the movie. And at the end, the German judge character asked for a private audience. He's been convicted. And he asked for a private audience with the Spencer Tracy character. So there's this wonderful conversation where the German judge tells the American judge, whenever I presided over that trial, and if you're a movie purist, I'm getting the quotations a little bit wrong, so please forgive me, but he says, whenever I presided over that trial, whenever we allowed the defendant to be railroaded, we didn't mean for all that came to pass with the Nazi state. We didn't mean for that to happen. The death camps, the Holocaust, we didn't mean for that to happen. And the American judge, Spencer Tracy, said, whenever you allowed that one man to be railroaded, you allowed the Holocaust to happen. It starts at the ground level, the nuts and bolts of what you do in your everyday decision making is where historical triumphs and historical tragedies begin. Now, all of these little three things I'm talking about, being able to sleep at night, the concept of simple justice, and what I'm calling the Nuremberg Effect, they all really do kind of overlap. Personally, with me, living one day at a time, not having a very good, accurate picture of what's going to happen 40, 50, 60 years. I can't even predict what's going to happen next Tuesday in a lot of places. But I've still got to go to bed at night, and I've got to rest with myself knowing that I have done the best that I can do under the laws that exist in this country and between me and my Maker to accomplish the right thing with those talents that I have. You have that exact same obligation. So tonight, if you don't sleep well, then you might remember a few of the things that are said during the course of this workshop. Thank you for your attention.
Thank you, Judge Ladd. Good morning. It's going to be my role to discuss in a minute briefly three reasons why the appointment of counsel matters to the county and its taxpayers. But as I stand here, Jim, and heard Bob Spangenberg talk about the years that have slipped away on us, I couldn't help but remember that and see some of you that I haven't seen in the last few years. Couldn't help but remember when Jim and I took this show on the road right after the Fair Defense Act passed, and saw many of you out around the state at conferences where we taught about the basics of the new act, and we called it the Jim and Jim Show. And we would, of course, we were laboring under quite a heavy load in trying to do that, partly because people kept introducing us as two brilliant Austin lawyers. And then they heard us talk. But we didn't realize, Jim, till I think much later, that there was someone else out there going around as a brilliant Austin lawyer. And some of you may have run into him, because I heard the other day that the brilliant Austin lawyer got on an airplane, Southwest Airlines, and he saw this beautiful blonde sitting there in an open seat by her, so he plopped down beside her and decided that he was going to impress her and get to know this beautiful blonde lady. So we started trying to strike up a conversation, but she wasn't having any of it. She went on reading her book and tried her best to ignore him. But the brilliant Austin lawyer would not be ignored. So he said, you really need to pay attention to me. I'm a brilliant Austin lawyer. And she still wasn't having any of it. So finally said, let's play a game. Let's play a game here. Said, I'll ask you a question, and if you can't answer it, I'll give you $100. Well, that got her attention. And then you ask me a question, and if I can't answer your question, I'll give you $100. And then I'll ask you a question. If you can't answer it, then you only have to give me $5. And the blonde said, well, okay. And the brilliant Austin lawyer said, and besides that, because you're a blonde, you can go first. So blonde said, okay. Said, let me ask you this question. brilliant Austin lawyer. What goes up a hill on 2 legs and comes down a hill on 3 legs? And he said, oh, good, a riddle. I love riddles. He said, let me think about it. He starts thinking, pulls out his legal pad and starts making notes and thinking about it. Nothing comes up, so pulls out his laptop, goes to work on it, Googles, gets out his cell phone, calls a friend, goes on Facebook, studies by it, but he says, this is a great riddle. I can't get it. So finally, he gives up and he says, I just can't get it. I don't know the answer to the riddle. And he hands her $100. And she takes it. And he says, but I just got to know. I got to know. What's the answer to the question? She said, damn if I know, and hands him $5. So, if you got $5 when we take the break, Jim and Jim will take it. Why does appointment of counsel matter to the county? As I said, I'm going to remind you of 3 reasons why it matters. Because if you're here, you already know these things. But as you may have figured out by now, that you're also here not just to learn, but we hope to go forth and be our missionaries in your county as well as in other counties. So we want you to go back and take these things home and spread the message. And tomorrow when we talk about the legislature and resources, we particularly will hope that you'll take it home and spread the message. But there are clearly 3 reasons why appointment of counsel matters to the county and its taxpayers. And the first one, if you're involved in the administration of justice, as most of you are, either as judges or in the administrative process, you already know this, that managing your docket is very important, that we have appointment of counsel. Judge Ladd just talked a little bit about those pro se defendants, and it's not lost on you as to what happens to your docket with pro se defendants and the inability to be efficient in the operation of your court. And it's no accident that those deadlines are in there on appointment of counsel. When the law first passed, many of us, as we went out and went from no system on appointment of counsel in this state to probably one of the most structured systems in the country, we got that question a lot. Well, Jim, why do you got those deadlines in there for appointment of counsel? Well, part of it is because we think it leads to a better system and better representation, but it also leads to more efficient administration. We found and know that the sooner you get the lawyer involved in representing the indigent, the more efficient the system will work. So efficiency of the operation of the courts is one reason why appointment of counsel is important to the county and its taxpayers. Second is the efficiency in the operation of the jail facility. And Bob touched on that we use a lot of jail resources here. And Judge Klager sits on that jail commission, and Commissioner Eggers, and tries to keep us out of trouble there. But we have a lot of people in jail awaiting trial. And appointment of counsel system, an effective, efficient appointment of counsel system, helps us use that resource less. How many of you in here are from a county where you have instituted a jail population committee? The members of the justice system working together, sheriffs, prosecutors, the courts, to ensure that those cases are handled efficiently. And certainly I think and can testify that a prompt and efficient appointment of counsel has a lot to do with that. If there's a reason why we put in the act the requirement that the attorney, once appointed, contact the client within 24 hours. And believe me, we heard a lot of complaining and moaning about that. But it leads to a more efficient use of our jail resources if that attorney contacts that client that's in jail and works with them and their family and their resources, particularly on trying to enable them to make bond prior to trial. And some of you, a few, I know at least, have found that appointing that counsel for that person in jail when they get out on jail, then sometimes they don't stay indigent. And sometimes we're able to get them off of the indigent appointment list. How many of you have a indigent appointment docket in your county where once counsel's appointed and the person is out of jail, that case comes back before the court for review as to its status, so that, number one, that person's back in court with a lawyer. If they want to work out a plea bargain, there's an opportunity to do so. But two, we find out and review as to whether they have made progress toward not being indigent any longer, and whether they can pay for their own attorney. So those are two clear reasons why it's important to the county and its taxpayers that we have appointment of counsel and have it done efficiently and effectively. The final one is one that Andrea Marsh, who will be on the program this afternoon, usually handles. I don't see Andrea here this morning. Oh, there she is. Hi, Andrea. And that cherubic-looking lady over there is your worst nightmare to your county and its taxpayers. Because if you don't have a proper system for appointment of counsel, you get to meet her in her adversary role, and you don't want to go there. Rothgary versus Gillespie County. I don't see anyone here today from Gillespie County. That's because they can no longer afford to travel outside the county, since it took all their money to pay the attorney's fees for losing that case to that cherubic-looking lady over there. But that's illustrative of the final absolute worst nightmare for a county and its taxpayers. What happens when your level of compliance for the appointment of counsel fails to meet constitutional standards? The state law, and I get this question a lot about the jail commission also. People ask me, why do we need a system? Why do we want Austin telling us what to do at the local level? Why can't I just run my court? Why can't we just run our county the way that we want to run it? If everybody did as probably the people in this room do, then that would not be an issue. But we know all too well that we need minimum standards and measurement of those standards and the application of those standards in order to keep some of us out of federal court. That the absolute bottom line is that the constitutional right to counsel, if not properly carried out and applied, will result in your county and its taxpayers paying the penalty for that through the federal court system. So that's the three reasons that this morning that I've occurred to me that my time is up. And thank you, Brian. And it's always good to be here, and I look forward to continuing on the program at two other opportunities during the time, and thank you for coming.